Hello, guys. This is Bill Corte from Bill Corte Properties, and today we are about to shoot another episode of Legal Matters with Bill Corte. We are currently at the office of the Spintex Road around the Bachuna area. Today, we are going to talk about rental agreements, lease agreements, and all everything pertaining rentals. Okay. Okay. So the very first question we have our lawyer here. Sorry, I nearly forgot about you. We have a lawyer here. He's going to talk about all these things with us, and we are going to go through it. We have lawyer Doe here, and he is the head of legal at Bill Court. Okay, so lawyer, you're welcome again. See? Right. All right. So the very first question I want to ask lawyer is, what are some of the key terms we should look out for in a rental agreement?
Okay. So with respect, we need to really understand what's a rental agreement.
Right.
Because there are two types. We have the lease, as you mentioned, and then we have the rent. So the lease can be a rent of a bare land or any
Right.
property.
Right.
But for rent itself, it must be a premise, either for residential purpose or commercial purpose. So you see, if you lease an office space, then you are renting the office space.
Absolutely.
But if you lease bare land, someone can come and have bare land for about 50 years, then he can even construct on the bare land. So that one is a lease. So
Okay.
under the Lands Act of Ghana, when that was passed, I think in 2020, that particular act provides for leases in general. And it says that there are specific terms that must deal with the obligations of the parties. So the most important term in the lease
Right.
is the duration of the lease. The duration.
Okay.
You must clearly state how long the lease agreement is,
Right.
because it gives the lessee,
Right.
the right to be on your land.
Right.
So although the land is yours, when you enter into a lease agreement, you give him the full right to be on the land,
Okay.
in possession of the land. So that means that you have to clearly state the duration of the lease. And then you have to clearly state the party, that is the lessor and the lessee.
Right.
And then there are what is known as the relevant covenants to the lease. The rent, the amount that is payable as rent is a
Right.
relevant covenant to the particular lease agreement. Also, there are certain covenants that deal with what you want to use the property for,
Right.
and restrictions against the use of the property, certain uses of the property. So, for example,
Right.
even the last act, they say there are covenants, implied covenants dealing with nuisance and annoyance. That means that we shouldn't use the property to commit any nuisance or annoyance to anyone, the
Okay.
neighbors and adjoining users of the property. Then there's also legality or illegality. You shouldn't use the property for any illegal purpose or immoral purpose. And then there are also covenants or statements or terms dealing with the repair and maintenance of the property, and also the fittings and the fixtures. So what you want to do to the property, if you want to make any additions or alterations to the property, is supposed to be contained in the agreement. So that is for the general needs. And then for the rent, as I said, it is the lease of a building. That one is more or less under the Rent Act, passed all the way back in 1963, Act 220. So for the Rent Act, it's dealing with the rental of an office space or a residential space. So the same terms and conditions apply. You have to state the most important term is the duration of the rent.
Right.
And then the amount to pay as rent. And then number three, the covenant. That is the promises that the parties make to each other. So the use of the property must be stated. Is it being used as a commercial property or as a residential property? How long is the property being used for? And what are the rights and obligations of the party? Who's going to repair, damages to the property, or going to make additions to the property? What are you restricted from using the property for? So some premises, they can even restrict people having children at the premises. It can be in the contract, a rent contract, that we don't have children in this residential building,
Right.
or we don't have pets
Right.
in this residential building. So these are some of the major things. So there are three parts: the duration of the lease or the rent,
Okay.
and then also the amount to pay as the rent. And then the third one is the covenant. That is the particular obligations the parties have towards each other. So these are the things you need to expect in the lease or the rent agreement. Yes.
Okay. The next question is, the rent, can it be increased without your notice?
Well, under general circumstances, rent is not supposed to be increased without the notice of the tenant. In fact, under the Rent Act that was passed in 1960 and 1963, Act
Right.
220, there is a rent officer and there is also a rent magistrate. So the rent magistrate is like the judge, and the rent officer is like an official of the state who needs to make sure that the landlord isn't cheating the tenant. So if they increase your rent without your knowledge, you can report to a rent officer. They are stationed in every district. Every district has a rent officer. But if the rent officer realizes that there is a need to increase the rent, that means that the landlord must communicate the reason for the increase to the rent officer.
Right.
So the landlord must communicate to you or give you notice that, look, from January, we have to increase the rent because of number one, inflation, number two, increase in the cost of repairs of the property and maintenance of the property, or number three, increase in utilities, etc.
Right.
So they need to give you information or notice in advance for probably a month or 2 or 3 months in advance period, depending on the terms of the contract. There are renewable clauses. You can renew the rent or review the rent. So if you want to do that, you have to give the person notice. And if the person doesn't agree, you inform a rent officer. So what the rent officer will do is that you will come and assess the value of the property and you dictate the rent that is correct.
Leon, do you think
Yes.
this thing works here?
Well,
This is
it
just
doesn't,
because it's my property. If I say I want to rent it at this amount of money, why would you? If you can't afford it, you should just leave my property.
So, in fact, there is a concept about the protection of the general rights and interests of the people. It's even a human rights matter. Imagine we are all staying in different houses, and one day all the landlords decide today that they are going to triple the rent. There's nothing you can do, all because so the state must provide a safeguard that even if you want to triple the rent, at least give notice to the parties. If they agree, that is it. If they don't agree to, then there are certain things that must come out of it. You can go to a judge, a rent magistrate,
Right.
a district court judge. For them, usually they are district court judges, and then they'll assess and review the rent. So if now I'm being charged 5,000 cedis a month as rent,
Right.
and then just 2 weeks they inform me that they're going to triple it to 15,000 cedis, I can go to a court, a rent magistrate, and then you review the rent and say, okay, maybe because of the upgrade in the property, you pay 7,500. That's how they do it. So if there is any dispute, my party doesn't
Right.
want to agree or someone agrees, you can take the matter to the court, that is the rent magistrate. Even to recover your rent, the landlord can report the tenant to the rent magistrate for recovery of rent.
Okay. I want to ask this question. Maintenance responsibility is for who? Is it for the tenant or is for the landlord?
All right, so there is an implied obligation on the tenant to maintain the property. There's an implied
The
obligation.
property that doesn't belong to the tenant.
Yes, he has to maintain the property because number one, he's in possession of the property. So if you've rented this office space, right, and the landlord comes to enter your space, he has breached your privacy. So even the landlord cannot enter this space because you've rented it and you've paid the rent. So it becomes your property, your interest for a particular period. So anything that occurs within the property must be maintained by you. You don't commit acts of wastage or acts of waste. So in law, acts of waste means any particular act that deteriorates or reduces the value of the property. You are not supposed to do it. Just reasonably maintain the property. If it's utilities you have to pay, pay. If it's sweeping or cleaning, do that. So the obligation is on the tenant. However, for major alterations,
Right.
so major alterations like even breaking down a portion of the wall, extending the building and all that, the obligation is on the landlord. And if the tenant wants to do that, he has to inform the landlord.
The landlord
Look,
about
I need to do a major alteration to the property. So let's have an agreement, and then that can be possible. But for general maintenance, taking care of the property, the obligation is on the tenant. In fact, in the law, that is the Rent Act 220, if the tenant doesn't maintain the property, it's a reason for the landlord to get an order to eject the tenant on the ground that the tenant is not maintaining the property. That is how it works. So the landlord can go to the rent magistrate for an order of ejectment against the tenant on the ground that the tenant is not maintaining the property well and has been committing nuisance or acts of waste on the property.
I see it. Okay, so the next question is, what happens if I need to terminate the lease early? Okay, if I decided to terminate the lease early than before, what happens? Are there other legal implications?
Right. So the legal implications are number one, either created by law or created by agreement.
Okay.
You see, most people enter into these rent agreements or leases without reading all the clauses. And sometimes no lawyer even drafts the lease for them. But even in the act, it says a lawyer must draft any transfer of interest.
Right.
The lease agreement must be drafted by a lawyer, but most of them don't, and that's where the legal issues come. You see, in the agreement, you have to stipulate that okay, if I end the lease, I can have maybe a refund or some of the rents that I've paid in advance. You can put it in agreement. There's an agreement between the parties. But if you don't do that, then it can be contested. I hope you got it because it's a contract. What is the landlord's issue? The landlord is supposed to give you the property for 12 months. You decide to use it for 8 months and you say you are going. It's not his fault. I hope I get it. Yeah. So what people do is that they do something known as subletting, right? Or sublease. They would give the remainder of the rent to someone else. You get it. Yeah. So that's how that's a loophole that many people use.
Because that's a very dicey situation there. Okay, let me move into the next question. For example, if you had a conversation with a landlord and you decided to just conclude on that verbal agreement, does it really stand? Is it something that can stand?
A verbal agreement can be a contract. So a contract can be based on a verbal agreement as long as there is offer and acceptance. So that
verbally.
But usually it doesn't apply to long leases. So there are short leases or short-term leases, like less than 2-3 years. Those or even 1 year. 1 year, pardon. They are short-term leases. So for that one, under the Lands Act, it's not necessary to put short leases or short-term leases into writing. Something like maybe a 1 year agreement or a 6-month lease. It's not really necessary. But then, putting it in writing is supposed to protect your interest. But if you don't put it in writing, it doesn't mean that you are cheated, you'll be cheated or you make a loss. The point is that if it's a short-term lease and it's more or less for like 6 months or 1 year, then probably not putting it in writing doesn't go to your disadvantage. As long as you can clearly express and the parties can clearly agree to what are the terms of the contract, then they are good to go. But what if there is a case? What if there's a case? Then to go to the disadvantage of usually the lessee, that is the tenant. Because obviously he would argue, but the landlord will have the stronger case, right? Because he's the landlord, the owner of the property. So you need to protect your interests by making sure that the property, the terms regarding the property or the particular premise are put in writing. That is what you have to do. So even if it's a 2-month or 3-month lease, you have to put it in writing to protect your interests. But it's not against you if you don't do so. Only for short-term leases. But for longer-term leases like 5, 10, 15, 20, 30 years, if it's not in writing, it is automatically initiated. To cancel that particular contract. Unless you can be able to show that the parties have reached a certain agreement and you perform the part. When you send money in advance, then we can agree that, maybe there is a particular verbal agreement that is partially performed. Then that one will consider. But if it's just a verbal agreement for a 50-year lease, how will you prove it in court? They'll just disregard it. Yes. So there are formalities. For long-term lease, you have to fulfill the formality of putting the contract in writing. That's how you do.
Okay. So let me ask this question also. For our line of work, okay, a broker like me, sometimes I get into this argument with lawyers and also landlords. The question is, landlords, are they, we have something called security deposit. Okay. Security deposit, what happens? When am I going to get that security deposit back? Because sometimes they want that assurance that this thing that I'm leasing it out to you, you don't spoil anything in it. And I'm going to use that to pay for it. Okay. So when do I get it back?
So under normal circumstances, it's the tenant that pays the security deposit.
Absolutely.
And it's usually to protect the property, right? The fittings, any furniture or fittings or any attachments that are on the property.
Right.
Is for the protection of the landlord's interest.
Yes.
So with the security deposit, once the end of term has ended and there is no there's no damage to any portion of the property. You are entitled to a full refund of the security deposit.
Right.
Because obviously during the period of the year, you might have done your own personal repairs to some of the to some of the fittings,
Right.
to some of the portions of the premises. So you incur your own personal repairs. So why aren't you entitled to have a refund of your security deposit? In fact, it is your right to have a refund of your security deposit. What happens most of the time is that usually the landlords will take advantage of just claiming that there was a damage.
Damage somewhat.
You get it? They'll just say that, oh, we saw some cracks somewhere. So
Right.
this one there we are seizing. No, you calculate the amount that will be taken to repair that, and you deduct it from the main security deposit. So if you pay 3,000 cedis as a security deposit and the damage is 1,000 cedis, then you deduct it and receive your 2,000. It's as simple as that. So it's not even a huge argumentative thing. It's just to protect the interest of both parties. That okay, at the end of the term, if I'm leaving the property, at least any minor repairs that needs to be made, the security deposit to cover for it. If there are no repairs that need to be made, then you would have to have, and you have to be entitled to your right to recover your funds. How we got it. So that is, it's as simple as that. Security deposit is recoverable most of the time. It will only deduct the amount that is needed for repair of the damages. And if it's more than the security deposit, then the tenant will have to pay for the excess costs. How we got it.
Right. What if there hasn't been any damage and the landlord doesn't want to fund them?
So this is a dispute regarding rent and all that. So number one, you report to either a rent officer or you go to the rent magistrate. That is the court, right? There's a dispute. And if there's a dispute, obviously the landlord will not agree unless there is a higher personnel that mandate or others him to pay or refund the security deposit.
Right.
So yes, in cases where you cannot find or you don't know any rent officer or probably any court, you don't know how to walk into the court, then just contact your personal lawyer. So the lawyer will now write a letter to the landlord demanding for the security deposit.
Okay.
And if the landlord refuses, they'll take it as evidence that
Right.
he made the demand and then the landlord refused. Then they'll gather all the evidence to show that there was no damage to the property. They'll gather the evidence to show that the landlord agreed to refund the security deposit if there is no damage.
Right.
Then they carry that to the court. So more or less, the rent magistrate will look at it and can order the party to pay the security refund, the deposit, and the security deposit refund. So they'll refund the security deposit to you. And they can even pay you interest and compensation for the delay and all that. Yes.
Okay. So I want to ask this question. What if the landlord, there's a crack or there is a defect on the property and the landlord is supposed to repair it? If the landlord says, I'm not going to repair it, what would you do? What should you do?
All right. So now, as I said, there are various kinds of defects or cracks or repairs that are needed. So imagine you enter into a new property or a new building. There are some things known as latent defects. So when you enter the property, you are not supposed to stay in a new house and after 2 months you are finding or discovering huge cracks in the walls. That has severe effects. They are called latent defects. That means that they are hidden defects. So any hidden or latent defect is supposed to be fixed by the landlord. If he refuses, you can immediately terminate the contract and ask for a full refund. It's your right. How we got it? Because you are not supposed to stay in a property that has latent effects. For example, cracks in the walls. You can be sleeping one time and then the building can collapse on you. So latent defects are defects that are hidden and that are structural defects. It's not your fault. So in that way, it's not your expense or your cost. But what if you were fighting with your wife and then you punch the wall and there was a crack? That one, yeah, it's yours. So you have to take care of it. So there's a distinction between latent defect and defects that were caused by the party itself. If you cause damage to the wall, that is alteration or breakdown of the wall, then you are supposed to compensate even the landlord for it or take care of the cost. But if it's a structural defect, even especially the piping, the plumbing system.
The plumbing work.
Yeah, the plumbing works. Most of the time, people enter the building and complain that, oh, the sewage, the smell. They have to go and get
it's
too much. They have to go and get their own plumber. And then also the electrical works. These things are latent defects. It's when you are staying in the property for some time before you realize that, oh, There are defects that when I inspected first, I wouldn't have known.
Right.
But then you have to stay. You have to use the washroom for a while before you realize the sewage has issues. So with that one, is the landlord's responsibility. Every latent defect is the landlord's responsibility. Hidden structural defects, they are the landlord's responsibility.
Okay.
But then any normal defects that were not hidden, that means that you could have seen it,
Right.
and
Right.
or you could have caused it. That one, the landlord is not responsible for fixing it. Unless you enter into an agreement that says that he should be responsible. If he signs that agreement, then that one is binding on him. Everything is by agreement. But what we know by law is that any structural or latent defect is not for the tenant to fix. It's for the landlord to fix. Because obviously the tenant didn't cause that effect or damage.
If you're watching this video, kindly subscribe to the YouTube channel, Bill Quality Realty. Also download that app, Bill Quality Realty app, Google Play Store or App Store.
Walking away, your words are lost on me.
Okay, so let me ask this question also. You know, sometimes there are issues cropping up on social media, whereby a landlord will just barge into his or her property. Is that legal?
It's not legal, right? So first you have to understand that there is a law known as trespass, right? The law of trespass. So there's trespass to land, and the person who is in rightful possession of the land can even sue the landlord for trespass.
Right.
Because under Article 18 of the 1992 Constitution,
Right.
you are entitled to the privacy of your home, wherever you are, and your correspondence, your home, your building, your correspondence, whatever. So this is your office. This is the privacy of your office.
Right.
What you are doing in your office is your business,
Right.
unless it is an illegal business or an immoral business. So obviously, if you discover that there is prostitution going on in a particular office, the landlord didn't give the office out for prostitution, so he can report to the police and he can barge in. So there are certain grounds under Section 17 of the Rent Act 220. It says that the landlord can repossess the property if the property is used for an illegal or immoral purpose, or the property is used to commit nuisance or annoyance. You there, you've rented the space and you've decided to be your own personal DJ, blasting the whole space in a commercial area. Then the landlord can come and then give you notice, right? So the landlord cannot really enter the property unless he has a solid ground for doing so in accordance with the law. And then he also has to give you notice that I'm coming for inspection or I'm coming to
prior notice.
Yes, prior notice. Usually they even say sometimes a month notice or sometimes 3 months notice. And so it can be in the contract that every year I'll do one inspection of the property. If you agree, then that's good. But then for the landlord to barge in, you can immediately arrest him and even go and report him to the police.
Yes.
If he doesn't have any right, he has trespassed onto your property. So although it is his property, right, he has given you for that duration the right over the property. So you can sue the landlord for trespass to your own and to his own property, especially if he had leased or rented it out, because he had made it clear that he's no longer in possession of it for that period. You are the one in possession, so you are the one who can sue. And apart from the landlord, you are the one who can sue anyone who enters your property, even if it's not the landlord. Anyone who enters
the landlord's wife.
Yeah, the landlord's wife. Sometimes they'll send their brothers or their agents. You can sue all of them. You can even beat them. You can arrest them. You can beat them. Yes. If someone barges into your property, you can fight back because probably the person is coming to attack you. You have the right to protect.
Yeah, you can beat them.
You can beat them. You can beat them. You have to arrest them and then report them to the police. They are committing a crime. It's trespass. Then that one you take it on from there. So you can report them to the police for trespass, and then they can be charged and they can even be fined for that particular.
Okay. All right. Next question. Instances where you rent the place. Now, you stayed in the place for, let's say you rented it for 4 years. You stayed in there for 3 years. Now it's remaining 1 year, right? Now you are going to, you sublet that to another party to live in that property. Can you be beaten also by the landlord?
No. So actually, it's a whole concept of law. Establishment or subletting the property. It's actually allowed that. Number 2 years. So there are two issues. Number one, if the rest of the lease is a very short term,
Right.
like a few months, then you cannot sublet without the written permission of the landlord. So if you have like 3 months left, you cannot sublet without letting the landlord know.
Okay.
Because obviously at the end of the term, the landlord will come to the house with you
Right.
and have a conversation with you on how to go forward.
Right.
So you cannot sublet without the permission of a landlord. If it is a short 3 months, 1 month left. But if it's more than the maybe 1 year or 2 years left, maybe a mini month, then in that case you can even sublet without letting the landlord know. You don't need this permission to sublet.
Really?
Just that after you've subletted your property, you have to inform him. You have to inform him that,
that this person is occupying my
yes,
space.
this person is occupying my space. And the general rule for sublease, right, is that look, you cannot sublease beyond the remainder of the term. Have you got it? You cannot sublease beyond the remainder of the term. So if I have 1 year left, I cannot give the entire more than 1 year to someone else. I have only 1 year left. So how come I'm giving the whole part of it to someone else? You can even sublet, for example, if you have 1 year left,
Right.
you can sublet 6 months. And then maybe you've traveled and you come back. So the person will stay for 6 months.
Right.
And when you come back, you resume the property. The landlord doesn't really need to do, because it's just just that the obligation is on the sublessor to respect the rights of the landlord. So the landlord has certain rights. So he has
Right.
communicated to you that don't use the property for prostitution, don't use the property for any illegal or immoral purpose. Then when you sublet it, the other person is now using the property for illegal or immoral. The landlord can come.
All that will
Yes.
be in the agreement.
All that will be the agreement. That respect the authority of the head lease,
Okay.
right? The head lessor. So that is a landlord. So if the landlord has leased the property to you
Right.
for 5 years, you can stay 3 years and sublet even 1 year to someone else. And then you come back for your final 1 year. Just communicate it to him. Just communicate it to the landlord. But then if it's just a few months left, then you have to get the landlord's written consent before you sublet. Then another issue is that people have an issue understanding the distinction between sublease and assignment. So if you have, let's say, you've rented the place for 5 years and there's only 2 years, you can assign the whole 2 years to another person.
Okay.
But if you assign a portion of your 2 years, that is the sublease.
Right.
So for the sublease, it means that you are still holding the lease, and then you just giving a sub, like a part of it to someone.
To somebody.
But for an assignment, you've assigned your entire interest in the lease to the person.
Okay.
I hope you are getting it. So if I have 2 years left, if I give the whole 2 years to another person, that's an assignment.
That's an
But
assignment.
if I give a portion of the 2 years to the person, that's a sublease. If I give 1 year,
Right.
it's a sublease because I'll still be the main lessee,
yeah.
and then there'll be a head lessor. That is the landlord. So there are distinctions. For an assignment, if you are giving the whole remainder of the property, it means when we are not even there. So who the landlord communicate with? That means that you have to inform the landlord or give notice to him and get his approval before you do that. But if it's a sublease, right? If it's a long period and you can sublet it to someone, you don't even need the consent of the landlord crowd. But at least afterwards, you should inform him. And you have to inform the sublessee that, oh, there is a landlord above you whose authority we must also respect. By using
Supersedes mine.
that supersedes mine.
Yeah.
And you must use the property
Right.
in a way that we have agreed to. Don't do it more than what the landlord has stated. Yes, so that's the general. So yes, you can actually sublet your property. You can even assign the rest of your lease to another person.
Another person. Okay. Let's say as a tenant, okay, you are living in the house. From nowhere, a tree breaks and fall on the roof. Now, that damage, who repairs it? Natural disaster, right?
Yes. So
That damage, who repairs it?
all right. So
Or maybe you are living in the house. Okay, that's natural.
yes.
Maybe you are living in the house and there is a vehicle barging into your house. It breaks, like let's say, for example,
Yeah.
what happened to the ladies who passed at
And the
East
recent-
Legon. Yes. What happens to like the it just hits the walls and it broke it.
Yeah.
Who repairs it? Who repairs
All right.
this?
So, sincerely speaking, every particular tenant landlord relationship, there is an insurance usually that is recommended because these things are disasters that you do not naturally anticipate to happen to you, right? You can lease 10 properties for 20 years, nothing will happen. The one property that you lease for 6 months, that 6 months, there can be a whole accident that maybe an earthquake. So what you do is that you enter into, you have an insurance premium. I hope you got
Okay.
that to protect that interest. That's the first part. So for huge leases for a huge number of years, you have to actually insure the property against such losses so that you indemnify. So this one, it doesn't matter whether landlord, you won't fight. We both pay the insurance, then the insurance company will come and indemnify us. That means they'll come and
The landlord will be the one paying the insurance.
well, it depends on the terms of the agreement.
Okay.
So the landlord will pay the insurance for any major losses, and the tenant can pay insurance for general maintenance or indoor losses. So, for example, the furniture, the fittings, whatever is within the house,
Right.
anything that is damaged, the tenant will take care of it. But for the structure of the building, is for the landlord because the tenant will go one day, and the landlord will still benefit from the structure of the building. I hope we got it.
Absolutely.
So it is in the landlord's interest to insure the building, and it's in the tenant's interest to insure whatever is contained within the building. That's how they do it.
Regardless if it's natural or
Regardless if natural or something. But then for natural disasters, well, more or less the contract is frustrated. So if there's a natural disaster and
Right.
the particular lease is damaged, the building is damaged, then the entire contract is frustrated.
right.
That means that, well, it's not anyone's fault. I hope because it's not anyone's fault. If you want the tenant to build the property, you're unfair to him. If you want the landlord to also build the property, you're unfair to the landlord. So what do? The particular terms will terminate. That means that a new contract will have to be made on how to settle the costs. And usually they'll put obligations in there that if there is frustration, then if I've paid rent for the rest of the year and the building was destroyed in June, then I'll not recover the rent
Right.
because the building has been destroyed. So obviously it's not the landlord's fault. And for the landlord too, if maybe he charged me rent and I've not paid and the building is destroyed, he won't come for the remainder. So that's how they do it. So it's a contract and the contract can be frustrated. And there are terms. The parties can determine what will happen if the contract is frustrated because it cannot be performed. You cannot stay in the house. But usually it's advised that to insure the property, and it happens a lot.
Right.
Unless the people are inexperienced, the property needs to be insured because even a fire can damage the whole property. So you have to insure.
The question is how many properties are insured here?
That's the thing. And most people don't have that kind of legal advice. They don't know that before you deal with properties, you have to make sure that property is insured. Most of the time when someone comes to purchase property, you have to ask them, look, is the property insured? If it's not insured, do you want us to do some sort of insurance on the property for you?
Right.
It's done at the authority. I hope you got it.
Right.
So more or less, there will be an insurance agent that will come and facilitate the process for you, and then you go and do your registration. You protect your interest. That is how it works out. But under general circumstances, these things are quite rare,
Right.
so people don't really anticipate it. But I know that's how insurance is. Even death, you can insure against death, either assurance or life assurance and stuff. Because all these things are unexpected events, but you can pay premium to protect against it. So that's how we deal with it. Yeah.
Walking away, your words are lost on me.
So what are the legal grounds for eviction? Okay. And how much notice is what required?
All right. So for eviction,
Right.
it's contained in law. You cannot just get up and evict a tenant.
Right.
The law must provide or give you reasonable grounds for the eviction of the tenant.
Right.
So the law is the Rent Act 1963, Act 220. It was passed all the way back in 1963 and it still applies today.
Right.
So what happens is that there is Section 17 that provides the legal grounds for eviction.
Right.
The first thing is that if you are not paying the rent, okay, it gives the landlord a ground to come and evict you from the property.
Okay.
But the landlord must give you notice that, look, you are not paying the rent. So I'm notifying you that if you don't pay the rent for the remainder of the period, I'll have to report you to the rent magistrate, and then we can get an order to eject you from the property. That is the first one. That's under Section 17, subsection 1B.
But you can't eject the person out of your own volition.
No. You can't just come out and sack the person from. It happens, in Ghana, we'll come and sack
Yes.
You ransack your house, you remove everything from
the house.
your house. No. That one is just to cause an inconvenience, and the person will just leave because he doesn't like the trauma or the dispute.
Okay.
But more or less, you are supposed to get an order to eject the person. As I said, once the person is in the property, he has his own privacy of the property. So you cannot just enter when the person is bathing and eject the person, or wait for the person to go to work. Then come and use padlock to lock the person's door. No, it doesn't work that way. The person can actually report you to the rent officer or the rent magistrate, so that will have orders against you. But then if you are not paying the rent, the landlord can inform the rent officer that look, these are the rents in arrears. Now usually if the matter goes to court, they'll order you to pay the arrears. And they can tell you that if you want to continue to stay in the property and the landlord has no issue, just pay the rent. You give, a schedule for you to pay your rent, and then you continue to be in the property. Maybe financial crisis or you lost your job. That's why. So you can be a statutory tenant, you can still be in the property, and then when probably you recover your money, you can now pay the landlord. So that's the easiest form of ejectment from the particular property.
Okay.
But then there's another one, as I said. If you are using the property for an illegal or immoral purpose, the landlord can go to court for an order to eject you.
Okay.
The rule is that it doesn't just enter your property to remove you. It must be an illegal or immoral purpose. So that means that you must be able to show, right? Now, in this particular case, it's more or less tuned to the illegal, because for immoral, we can't really define what is immoral, right? I know, for example, a landlord discovers that there are gays in the particular property. You not just come and inject, because gay is, homosexuals is immoral per se, but the illegality is still being in law. You get it?
Right.
So more or less, if the person is committing a crime like fraud, it's a hideout for criminals, you go and report to the police.
Right.
They'll come and take the necessary orders. They'll go to the rent magistrate, and then you'll be ejected from the property. The third one is nuisance and annoyance.
Okay.
That is very common in Ghana. Nuisance and annoyance.
Right.
Landlords have been using this a lot. More or less, most people enter the property and they become a nuisance to almost every other adjoining tenant.
Tenants.
Usually, there are most of the time you don't rent property alone. You would rent with co-tenants, right? So it can be a building with multiple flats, or multiple rooms, etc.
Right.
And you rent out portions and bits of it. I hope you got it.
Right.
So you can be a part tenant. That means that you're a tenant of a portion of the property. So if you are committing nuisance to other people, there was a case where a lady was found with food. It actually went to court. She had literally a shop bar
Right.
in the commercial building. I hope you are getting it.
In a residential,
in a residential building. Yes. But then if you are founding on the top floor, obviously people downstairs will be scared.
Yeah.
Because just boom, 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 boom.
Yeah.
So that is nuisance. You are committing nuisance against the others. So with respect to nuisance, it causes severe grounds for the landlord to come and get you. But I'm trying to make it clear that the landlord must get an order from the rent magistrate. He can't just enter your house and see he believes you are committing nuisance, so he wants to sack you. No, you must get an order from the rent magistrate. Quite shockingly, act of waste. If you are wasting the property, the whole property is deteriorating.
Okay.
If you see it, you understand what I'm trying to talk. You give someone property and you come back after 2 months and all the walls are still. The whole property is deteriorating. That one, the landlord can go and apply for an order to check. You have to show proof that you've intentionally started committing acts to deteriorate the property. That's what happens. Then the most common one is obviously when the landlord leaves the property back.
Okay.
Now, under certain circumstances, it is allowed for the landlord to go back into his property that he has leased to you. Number one, if he needs the land, if it's a residential premise or a residential building, and he needs the particular building for his own dwelling house or his own dwelling space. So that means that the landlord was probably staying somewhere, and then more or less he leased or rented the building to you, and you are staying there. Then he realizes that probably his rent has ended at the other place, and he has nowhere to go. He has to come back to his property. So if the landlord wants to recover his own property, he has to show that it is his dwelling place and that of maybe a family member, right? So your family member is exclusive to your wife, your children, and then your parents. It's not less to your external, and this always in great uncles, daughters, niece, best friend or something. No, it's not your cousin's best friend. No, that's not your family member. It's man related to you by blood. So your parents, that's your mother and father, and your kids and your your spouse,
Right.
more or less, those are people regarded as family.
Right.
You can do that. And then another important thing is that what if the landlord gave the building to you as an employee? You are his employee.
Mm.
You get it?
Right.
That means that obviously if the employment has terminated, the person should have the right to
evict.
vacate the property. Yes. So that's by agreement. You've entered into an employment contract with someone for 2 years. So that means that you gave you a rented bungalow for 2 years. The 2 years has ended. Obviously, you step
leave.
out. That one is not a big issue. So he has the right to come and reject you because your rent has ended. Now, yeah, if you are not his employee, but he has an employee who wants to use his building for work purposes, then he can give you notice
Right.
that although it's not your fault, his employee needs the building because he needs it to work. So they can give you, I think, some month notice, and then you actually leave the property for the person. Now remember all these, they got to weigh the convenience. If it's more convenient to the other employee to get another alternative space, then they will not give you the order. If it's more convenient for the landlord to stay somewhere else,
Right.
then they'll not give him the order to come and recover the property. I hope you got it.
Right.
So these are the main grounds for the recovery of the property. Another last one is for especially building premises. He wants to remodel the property. He has to give you like 6 months notice and tell you that look, if the business come to end, the rents come to end, I want to remodel the whole property. I want to break down some portions, upgrade my property. So he has to give you notice. And after giving you notice to when he finishes with the remodeling and the property is now nicer, he has to give you the right of first entry. So you must be the first person that you give an offer to that you can enter the property. You can pay the rent and enter because you left for him to develop the property. You have the right to come back and say, oh, can I pay? Then if you don't agree, then he can offer it to someone else. So these are the main grounds. Number one, non-payment of rent. And number two, breach of your obligations. You are supposed to use the property for a good purpose, commercial or residential, not a criminal purpose.
Right.
And they are not supposed to commit nuisance or annoyance on the property. They are not supposed to waste the property or deteriorate the property. And you are not supposed to
waste the property. Then, for example, if I want to ask this question, you've rented a place, but now you don't live in the place again. Is it what happens?
In fact, it's the landlord's specialty that you rent the place and you don't stay there. You know why? The value of the property.
Nobody living in the property.
Well, you see, the deterioration in that sense means that you've neglected. There's a difference. You've been neglected the property.
All right.
So it means that it's not that you're not staying there. You've neglected it. There are many people who don't stay in their property
because you're obliged to stay in.
Yeah, you're obliged to stay in only to take care of the property. Because if you leave a house for just 3 months, when the people come back, the bush, the way the house
would have webs and everything.
Yeah, so that one you have to. So many people don't stay in their properties, but still they need to inform the landlord. But I said it's a landlord's dream because once the property is being maintained and you are not staying there, you are paying him rent, he's happy.
It's good.
He's good. So you just tell you that look, maintain the property, get a cleaner or a housekeeper. Get someone to enter the property, even if it's twice or 3 times a week, to just clean the place. That one we are okay. Pay your rent, we are good to go. The property will be maintained. Because there are many instances where a building will be completed, but it even takes 6 months before they get a partner. Sometimes. So in that way, who is taking care? So there's a caretaker. There'll probably be someone doing the sweeping. So that's why it is.
But isn't it breach of contract also if you don't live in, because you're obliged to, as a tenant, you're obliged to live in the property.
Well,
isn't it breach of contract?
Then most of these rich men will be sued for breach of contract. There are rich people who can have multiple properties and they don't stay. They will just have a caretaker there. Right. So if you say
for you the tenant, living in the property,
it's your breach of your obligation. You're supposed to live.
You are supposed to live in, but you say you're not living in.
But you pay the rent.
You pay the rent.
And you maintain the property.
You don't maintain the property.
If you don't maintain the property, it's acts of lease. Okay. Because if you don't maintain the property, it's acts of lease. Right. Because why are you, this is the name, not maintaining the property?
Not maintaining the property.
But then the issue.
That's also breach of contract for you.
It's a breach of contract, yes. So in the law, they don't say it's breach of contract if you are not in the property. In the law, they say it's breach of contract if you are wasting the property. So it's an act of waste if you are not in the property and the property is deteriorating. That means that you've neglected the property.
Okay.
Right. But if you are not in the property, you're a rich man who has been traveling to other countries for months doing business, the landlord, is even your best friend. He likes that kind of agreement. All you have to do is that you can inform him, you'll get a credit to be dealing the property and taking care of the property, and then they'll just be paying him a portion out of the rent or something.
Right.
You get it? So that is how it works. So in the law, there's no statement in the law that says that you have to be in the property. The statement in the law is that you do not waste the property. So if I rent the property for a year and I'm not there, I'm wasting it. Why? Because no one is maintaining it. The property must be lived in to maintain the integrity of that particular property. So we are not renting it for people to just waste it. We are renting it to people who can either maintain it or stay in it. When you are staying in it, you maintain it for your benefit, right? So it will also be to the benefit of the landlord. So the statement in law is it's not really about paying or not paying. The statement in law is about maintaining.
Right.
So you can decide not to stay in a property. Probably you've traveled for 6 months, but you still want to keep the property. So you get your cousin to come and stay there and maintain the property. It's as simple. In fact, he's even staying in it. But there are people who come and go. So he's not staying in the property, but he's maintaining the property. The landlord will be okay.
So far as you maintain the property, you are good.
Yeah, but that's the rule.
Okay.
So you cannot say stay in the property. You can tell the person maintain the property, but you cannot force someone to stay.
Stay.
But you can force him to maintain.
Absolutely.
That's
Absolutely. Right. This is a very controversial question I'm going to ask. Okay. It borders around discrimination. Okay. Example, I'm just going to use this as some people don't like Nigerians or other foreigners in their property. It's a white man, they allow. But when it's a Nigerian, when it's a Togolese, that becomes a problem. So what happens? Is it a law? Can you file a lawsuit against that landlord for discrimination?
Perfect. So it is two contesting rights.
Right.
Number one, everyone in Ghana must be free from discrimination.
Right. And also tribes. Yes. They say that I don't like this tribe.
Oh yes,
This tribe is not
don't like
back.
this or that. Yes. So it's more or less-
Even aside the tribe too, I'm going to add more to it. Aside the tribe, partisan politics too comes in. They say you are an NPP or an NDC or a cheddar person, and you are not supposed to.
This election, the landlord can use send some
Yeah. For violation.
Yes, for the way you be
Unnecessary.
or in my property.
Yes.
And you know that I'm a strong maybe NDC or NPP person.
Yes.
Please, let's end it.
Let's end it here.
No, it doesn't work that way. It's actually discrimination. Okay. So the good news about discrimination, the law against discrimination, and Article 17 of the 1992 Constitution,
right,
is not allowed. So every person must be given fair and equal treatment. No person must be discriminated on the basis of the gender, on the basis of the race or the nationality, or the ethnicity of the person, or the political opinion of the person, or the ideology or the religion of the person. I hope you got it. So that is it. So it covers Nigerians, Togolese, NPP, NDC, LS, Northerners, Akans, Asantes, anyone, Bunus. It covers everything. It says tribe, gender. So that's how people can say, we don't rent to women. When we rent to women, we have issues. But when we rent to men, they'll just come and go feel free. But women, it becomes like either problems, they're always fighting the house. No, that is discrimination. How we got it. So what can you do as a landlord? Number one is your property. Okay. So who you rent to is your own, is your house.
Yes.
So you see there's a balance because I said the next provision is Article 18. That says that you are entitled to your own property and your privacy of your property. How you manage your property is how. So if I have a car and I say I don't want to sell my car to a Nigerian, who should come and arrest me? It's my car. It's my house. If I have a vote and I say me, I don't sell my vote to Asantes. Right? Who should come and arrest me? It's my vote. I can sell to anyone. So in that case, there are two things you have to do. Number one, you do not publicize it. You do not put it out there.
That means you don't want this particular.
That means you are discriminating against the whole world.
Okay.
But if a Nigerian comes
and you say it's occupant or something,
so it's the property. So we come and see that you say your property is occupied, but it's not occupied. You can tell that maybe I was in talks with someone. You get it?
Right.
So of course there's discrimination, but there are loopholes. And I'm not teaching you the loopholes. I'm saying as decent, in like a reference to decency. You don't tell someone, I'm not giving you a property because you're Nigerian. No. It would, the kind of,
but what if you feel like he didn't give me that property because I'm a Nigerian?
Well, it is your property. I hope you are getting it. That is the difference.
Yeah.
But then you do not discriminate. So you do not put it in
No,
a
but no,
discrimination.
maybe he doesn't. Maybe the landlord
Mhm.
doesn't spell it out
Yeah.
that for you. I don't.
Mhm.
You will say that, oh, you, which tribe are you,
Mhm.
or where are you from?
Mhm.
The mere fact that he's saying that means that he's trying to single you out
Mhm.
and use that against you.
Mhm.
So
Well,
what happens to
as
that?
I said, right?
Yes.
There is a distinction. So you see, if it's a private conversation on says, look, I've had maybe a bad experience with this particular group of people.
Yes.
So I don't really want to deal with Nigerians in my house. And,
Right.
but then you tell the person like, oh, okay, why would the person go and sue you in court? Do you get it?
Right.
Why would the person go and sue you? If you are going to buy key and the person looks at you and says, you are sad, I don't like people with beard, you get offended and you go. Like, I mean, you get it.
Yeah.
Right. But then for you to publicize it is the issue.
Okay.
Because the discrimination is against the whole world. The law says that you do not discriminate against anyone just on the that means you are discriminating before you even saw the people.
Mm.
You get it? So you put a big notice, house for sale, no Nigerians, no errors, no NPP people allowed. That one there no really report. You get that? That is different. But if a Nigerian comes and asks you and say, oh, the place is occupied, and no one's come to force you to rent, no one can force you to rent.
Right.
You get the distinction.
Right.
So there are loopholes. Obviously, the law cannot arrest anyone for discrimination. You know, we all do some kind of discrimination. Even in the choice of our spouse, we discriminate.
Right.
So maybe I can say I like slim ladies. So I'm discriminating against big ladies. Or I can say I like big ladies. I'm discriminating against slim ladies. But it's a choice.
I mean, that's
No, it's
very arguable.
But if I go and post on my
That's
my wall that I'm looking for a cleaner, no errors, no Asantes, no Nigerians allowed, that is it's offensive.
yeah.
It's tribalistic, it's bigotry. It's offensive.
Yeah.
But then if I'm looking for a girlfriend and it's my private, conversation with the person, I say, oh, is it true your parents are parents? I don't like parents. Some of them might complain that the stereotype against this group, but there's nothing you can do. You can't go to court. So your personal choice is different from discrimination. So discrimination means that you're putting it out there in the whole world that even before the person approaches you, cancel.
Cancel
You can, yeah. That one, it's actually in breach of the law. But if the person comes and you have a conversation with the person and you even convey the idea to the person says, oh, I'm Nigerian. Understand your issue.
Right.
Most Nigerians in Ghana, you see, most Nigerians in Ghana might come here and do business, and some of them can be involved in crimes or fraud. So understand that I'm a businessman. Here are my credentials. So although I'm Nigerian, I've stayed in Ghana for over 10 years. I've even married a Ghanaian. So you, the landlord will be like, oh wow, okay, let's consider. Look at your business, look at your marriage, you get it. Then there's a personal conversation.
Okay.
So I've met Nigerians who were offended, but they can explain it to the landlord, and the landlord agreed. And even later on, the landlord will come and say that this Nigerian has even been the best tenant.
Right.
It's the Ghanaian in the other house that is rather
Giving
me problems. And that's how it is. Right. And it happens everywhere. You can also go to China and then they look at your face and they will say that that's
black.
But you're black. It's so cool. There's really nothing you can do about it, honestly, these days. But so you get someone who rents to you. That's how life is. You get someone who rents to you. Just that you might not get the place that you want. That's how it is. Even in business, you want to open a business in a country, the business has laws against foreign participation. Even Ghana, we say foreigners cannot engage in small scale businesses, but they do indirectly. So a foreigner cannot open a momo shop or cannot open a bread shop in Ghana. But if you go to the books, what they do is that they'll open it and they'll go and put a Ghanaian there to be operating. Excuse me, say most of these Lebanese, you get it. They can open restaurants and shops. And then they'll have Ghanaians operating. And the law is cool. It's like, okay, you can employ Ghanaians, I think helping the economy more than, people who.
So it depends on the context.
Yes, it depends on the context too. So discrimination comes in all forms. But you to put it out there and publicize that before the person comes, you've already cancelled in the spirit.
Right.
That one is out. That one is out. You can actually leave. And you can actually have issues coming up against you.
Okay. I think we've touched on major issues, major problems pertaining rentals. Thank you very much for coming around.
This has been an intriguing one.
Yes. So can you subscribe to the YouTube channel Bill Corte Property Ghana on YouTube and download the app Bill Corte Realty app on Google Play Store and App Store. We have a lot of properties out there. Perhaps if you are looking for a place to buy, if you're looking for a landed property, if you want a place to rent, just log on to that website or app, billquarterrealty.com. You can also log on to that website and sort it out. We are out. Watch the next episode up there. Thank you.